So you've been sued for debt collection, or maybe you expect to be sued. Here are a few things to know about how to defend yourself in a debt collection lawsuit. A set of things you should know to help you win your case. Number 1. The importance of answering the complaint. A creditor or debt buyer starts a lawsuit as the plaintiff by filing a summons and complaint that says you owe them money. They give it to the court and to you, the defendant. You then file something back called an answer. Here you start to tell your side of the case. You have 30 days to file your answer. If you don't, you will lose automatically, called a default judgment, where the plaintiff usually gets whatever amount it seeks. Instead of not responding at all, you have the right to file something called a general denial, which basically means you tell the plaintiff to prove it. Prove you owe a specific amount of money to that particular company. Number 2. Defenses to put in your answer. These are defenses you may have, legal reasons why you should win the lawsuit. An excuse or explanation of why you were not able to pay is not a defense, even if it's a good reason. It doesn't matter how unjust it seems. You need to have a legal defense, not just an excuse. All the judge has to decide is whether you owe the money and, if so, how much. Now let's go over some common legal defenses that are reasons you should win. You don't owe the money. Use this defense when you simply don't owe the money that the plaintiff is asking for. Seems obvious, but it happens. And remember, the plaintiff has to prove that you owe the money to them and how much. Even if you owe them something, you may not owe the amount they say. No business relationship with the plaintiff. Use this defense when you don't know who the plaintiff is and how the plaintiff has the right to sue you. Because you never signed a contract with this plaintiff, there must be proof for the court that you owe them money. You already paid some or all of the money. Use this defense when you did owe the debt but have paid all or part of the money that the plaintiff is suing you for. If the debt is paid off, it's paid off. If you paid part of the debt, you should only have to pay the rest that you really owe. Use this defense when you are the victim of identity theft and someone has used your name to get a credit card or borrow money. You are not responsible for debts that a thief made using your name. The lender did something wrong. Mistaken identity. Use this defense when you're sued for somebody else's debts, usually because you have a similar name or identifying information. An unfair contract. Use this defense when the plaintiff violated your rights when they lent money. The agreement is very one-sided, or they have not dealt with you in good faith. Or they brought the lawsuit too late, after the time has run out. After judgment and payment. If there is a trial and the court decides that you do owe the money, you still have rights. First, you don't have to pay a judgment right away. Second, South Carolina has laws prohibiting wage garnishment for judgments on consumer debt, like car loans, credit cards, and personal loans. This means that the creditor can't get a payment automatically deducted from your wages just because they got a judgment. Third, to collect a judgment in South Carolina by taking property, the creditor must go to court again and ask a judge to allow it to take your house or other property. If this new judge decides your property is protected from the judgment, then you are not required to pay anything. So you should consider going through this process, not agreeing to a payment plan. And finally, fourth, in South Carolina, you cannot go to jail for failure to pay a consumer debt or a judgment on one, and don't let anyone tell you that you can. These defenses can be technical to prove. We recommend you find a lawyer to help you. You can try us at South Carolina Legal Services or the South Carolina Bar Lawyer Referral Service.